Simmons, let me know when we're live. All right, we're going on the record on cause number 208352, Parker v. Doyle. Counsel, make your appearance.
Joey Said for plaintiff Doris Allen Parker.
John Stillwell for
Okay, let's go forward.
Well, we got a couple of motions today, Judge. We have a competing motion to compel and a motion to quash, but I think it would be more prudent to address the defendant's motion to sever and abate because I believe that might be the holdup on why they're unwilling to produce the corporate representative. So we'll go ahead and start with that.
if we're going to do that, could I argue my own motion?
Yeah.
All right. Yeah, Judge, I mean, as you're familiar, this case involves declaratory judgment action by the plaintiff and bad faith claims. And we're just trying to sever and abate the bad faith. I think that's consistent with the law. I mean, without going into it, I mean, I'm sure the court is aware of the decisions, even from the Dallas Court of Appeals and others, that the bad faith claim isn't right until there's a judicial determination of legal entitlement to recover and then the insurance company fails to pay. The Dallas Court of Appeals in 2018 even said that the trial is the adjustment of the claim. I don't necessarily agree with that. I think it was oversimplistic, but that's what the Dallas Court of Appeals said. So we would just like to sever and abate the extra contractual issues. And that would at least narrow the issues on the motion. I believe those are routinely granted. So.
I can barely hear you now, Mr. Stillwell. You're being very quiet.
I believe the motions to sever and abate are routinely granted. We asked for it. I believe there's 2020 cases that say that it's error not to sustain those. I would ask that we sever and abate just the bad faith claim from the declaratory judgment action.
Mr. Said?
This is not a normal routine motion to sever and abate, Judge. What the defense is trying to do is to conflate a breach of contract claim with a declaratory action. The declaratory action, the Civil Practice Remedies Code, says that it's to declare rights, status, and other legal relations, whether or not further relief is or could be claimed. This is not a breach of contract claim. While a breach of contract claim does require an entitlement to recover, this is a statutory violation under 541. We did not allege a breach of contract. We do not allege that Allstate breached their policy. We're alleging that their settlement offer was unfair. The only requirement under 541 is a 60-day notice prior to bringing a suit under 541. The standard is whether the insurer's liability has become reasonably clear. And a court ruling in 2002, I put it in my motion. What the defense is essentially trying to do is, if we obtain legally entitled, a judgment against them under a breach of contract claim, then the relationship between the my client and the insurance company becomes that of a creditor and a debtor. And then we would be precluded from bringing the statutory tort against them. There is no claim to sever and abate. It's a declaratory action to declare the rights that their liability is reasonably clear, and we're alleging that the settlement offer was unfair.
Okay, response.
You'll have to show a legal entitlement to recover. This is really a bastardization of the term declaratory judgment action, in that declaratory judgment actions or to declare whether or not to declare policy construction. We don't have the policy.
Mr. Stillwell, you said that there's a 2000, I thought you said 20 case that's right on point out of the Dallas Court of Appeals. Can you share screen that?
Well, I'm trying, no, there's 2018 case. There's other 2020 cases that found that it was error not to sever and abate. And because I had the other hearing and because I thought this was so routine, I frankly don't have this up, but let me pull it up. There's 2018 case in December of 2018 from the Dallas Court of Appeals. I'm trying to remember, it was Progressive was one of the parties. I think it was Weber. That basically went through the process and the declaratory judgment action. It doesn't make any sense. He makes mention of a 2002 case, which guess what? That's before. That's before the Texas Supreme Court ruled in Brainerd. There is one old case that's pre-Brainerd that says that what he's talking about, but everything since then is it's appropriate to sever and debate. Let
me provide you, Your Honor, with a more recent case, USA Texas Lloyds versus Menchaca. This is a Texas Supreme Court from 2018 that specifically held that an insured need not prevail on a separate breach of contract claim to recover for statutory violations.
And
that is in my motion.
That doesn't involve a car wreck case. In that case, actually, the cases have distinguished that. That is not applicable in any way, shape, or form.
It's on point to this case because it involves the question between the relationship between a breach of contract claim and a tort under a statutory violation.
No, it doesn't, because in a property case, they don't have to show the legal entitlement to recover. In a car wreck case, they do. And that's the distinction.
I'm just going to maintain that the only time that Brainerd applies is if there's a breach of contract alleged.
That's not true at all. Not true at all.
So,
Brainerd does not mention statutory violations. It doesn't touch on the issue.
Brainerd has to do with the first party. Brainerd was the landmark case that came down in 2006 that said that you have to show legal entitlement to recover. Otherwise, it's not right. And it is, I mean, this is like 101. This is like no one should even be arguing. And to argue that Menchaca applies to a car wreck case is not even candor to the tribunal in any way, shape, or form.
Mr. Stillwell, this is the reporter.
I'm sorry?
Mr. Stillwell trailed off. I didn't get the last part of his comment.
Menchaca doesn't apply to car wreck cases is basically what I'm trying to say. It is a property case, which I understand the distinction. And it's been distinguished. All we're trying to do is sever and abate the extra contractual claims from the declaratory judgment action claims. And then let's see what happens.
Plaintiffs maintaining that the declaratory action is to declare legal rights and relations between the parties and not to allege a breach of contract. The Fifth Circuit in Hamburger versus State Farm discussed this very issue. They held that no extra contractual claim can be brought when there is an entitlement to recover. When that judgment is made against the defendants, we become the creditor, they become the debtor, and the statutory duty of good faith no longer exists between the parties. we're not going to bring a contractual claim against them. We're not alleging breach. They did offer. That is performance.
The
Well,
Supreme Court years ago in a non-insurance case said, and I can find the case site if you want, that to do what the plaintiff attorneys are now trying to do would basically say that you can call any case a declaratory judgment action. For example, you could call the car wreck case.
Isn't there a case in the Texas Supreme Court right now that's, and I remember someone talking about this in another hearing, or maybe it was judges were talking, that said that, anyway, there's a case in front of the Texas Supreme Court, as I understand it, on the issue of whether or not you can make a declaratory judgment action in a UIM case. Are you guys familiar with that?
I am. That case
I don't
is
think
really,
they've made a decision yet.
that case is the Irwin case. And that case, the issue really is, can you get attorney's fees? I don't think anybody argues necessarily with the fact that, like, for example, the Jordan versus Allstate case about 3 or 4 years ago out of Texarkana Court of Appeals, the trial was in Waco, but they transferred to Texarkana. That case said that you could do a declaratory judgment action, but you couldn't get attorney's fees because to do that would mean the Daisy Galvan case, all that the same law firm would have to do is say, Judge, we're trying to sue for a legal declaration of our rights against Besner and Smith. And then, lo and behold, we get attorney's fees. That's preposterous, absurd. But you're right, there is a Texas Supreme Court case, I believe it was the Irwin versus Allstate case. Actually, at the Supreme Court, it's called Allstate versus Irwin. And it has to do with, can you get attorney's fees on a declaratory judgment action in a first party setting? And that is that's set to be heard in January. That doesn't deal with the severance and abatement. If I may share my screen, I'll show you. I haven't even looked at all these cases, but I'll just show you 2020 cases to deal with it, if I may.
Sure.
I have not been briefed on any other cases beyond defense motion.
Okay.
Here's,
Let me just look.
well, then we can cancel the hearing and we can cut all this and we can come back if he needs to be prepared. But this is just a search. I searched for sever, abate, declaratory judgment 2020. Okay. Progressive versus in-rate progressive, July 8th, 2020. Trial court abused its discretion by denying insurer's motion to sever and abate. This one has to do with competing interests. Not exactly sure what this is.
I don't think that one's relevant.
This one is in-rate State Farm Auto Insurance 2020. Houston insurer was entitled to mandamus relief because yada yada. It says may be rendered moot depending on the adjudication of a declaratory judgment action. Here we go. State Farm should not be required to litigate them or answer discovery about other claims before the declaratory judgment action is resolved. So we have declaratory judgment, we have sever and abate. The insurer was entitled to mandamus relief when the severance and abate was denied. Let's see here. Here's October 20th, so a week or two ago, Houston. Trial court erred by not severing extracontractual claims against breach of contract. I think the courts have basically held, the plaintiff bar has kind of decided, based upon some rulings, like the Progressive versus Weber case out of Dallas Court of Appeals in 2018, that maybe a breach of contract case is not even appropriate. Some law firms do file motions for summary judgment. I think a declaratory judgment, breach of contract, we all know what they're trying to do. They're trying to find out, is there liability of the tortfeasor, and how does that measure up with what they've received so far, and how much are they entitled to?
Judge, if I may briefly respond, What we're looking at right now are summaries of cases, and they're referring to something called extra contractual claims. That could be statutory violations, or that could be the tort of negligence. And most of these are.
Why don't we do
Negligence
this?
is not
I kind of agree with Mr. Stillwell in this one point, which is maybe we should reschedule this to give both sides an opportunity to brief this. What I've generally done in cases in the past is I do generally abate and sever and abate the extra contractual claims. The bigger issue is I don't usually sever and abate the declaratory judgment action from the underlying liability case. But I think that's discretionary is my understanding of the law. But I do want to give Mr. Said, I agree with him, an opportunity to do additional briefing on this issue. So that's the first motion. So we're going to kind of give Mr. Said an opportunity to do additional briefing. And then if I need any additional briefing at that point, I'll ask Mr. Stillwell for it.
But we really need to resolve that issue before we can do the others. And this really do, because that's the whole issue. Do we need to engage in discovery on extra contractual issues? And like, for example, this court, I mean, he says it's no insurance code violations in Ray State Farm 2020. I mean, mandamus relief, they needed court's refusal to abate extra contractual claims. We've talked about, he wants to know, and negligence is not an extra contractual claim. They haven't sued the insurance company for negligence. He threw that out. Extra contractual is always an insurance code violation, DPPA. I mean,
so it's interesting you raised this. I actually had an intern this summer write me a memo on the issue of whether or not you could compel a corporate rep deposition of an adjuster. And of course, this was a few months ago, so there may be more current law on this, but I'll give you kind of the conclusion of it. It said, yes, there's a split in authority. The San Antonio and Corpus Christi Edinburgh Courts of Appeals compelled insurers to produce corporate representatives to be deposed on UIM cases, particularly when the insurer contested liability and damages. The first District Court of Appeals in Houston, however, quashed the deposition of a corporate rep on a UIM claim because it was not yet ripened, as no judgment had been obtained on liability. So there, at least as of that point,
and the Supreme Court, you're right. There's a split in authority on it. And
Judge, if I may, just real quick, a motion was filed and we responded, briefing the court. And if Your Honor does find that it's discretionary to sever and abate, or not to deny the severance of a DEC action from a 541 claim, then plaintiff's requesting that you deny defendant's motion right now, specifically because my client is 77 years old and we cannot afford to delay in this case. Right now, what I've been faced with is a last minute slew of summaries from an internet search in order to delay this case. I think I think you'll find in my motion that it provides enough case law to have a ruling today.
that's wrong. That's wrong. You're supposed to sever and abate. It's error to not sever and abate the extra contractual issues. I mean,
all defense has is that this is routine and a bunch of summary things that he has not put in his motion.
That's not true. We've got a motion. We also got some 2020 cases, like the In-Ray State Farm case, where it deals with insurance code violations, DEC action. It was error.
I've already ruled on this issue, so let's move on. We're moving on to the quash issue.
How did you rule on that?
I said that I'm going to give him an opportunity for additional briefing.
Well, we need to resolve that issue to determine the scope of the deposition.
Okay, scope of the deposition.
Yeah, whether or not you get to take the deposition, I acknowledge that there is a split in authority. There's two Houston cases that say you can't. There's a couple cases that say you can, but all the cases say it's limited. They don't go into how did you value the case. I think it's usually claims and defenses. What are they? I will acknowledge that is the cases that stand for you can take the deposition. I think they're limited to claims and defenses, but not, hey, how'd you value this claim? And if we want to limit the
I do agree, Mr. Stillwell. So I'm going to allow the deposition on claims and defenses. If you guys have a difference of opinion on which topics exactly need to be, or appropriate or not appropriate, then submit to me 2 competing orders. Let me know you're submitting 2 competing orders, and I'll do a baseball arbitration, which means that I'll just pick one of the orders or the other. So
as long as we're talking about claims and defenses, I'm fine with that.
You need to come up with an order for me.
Okay.
All right, guys. Thank you so much. And we need to get to the next one, okay?
All right, thank you, Judge.
Thank you. Do we have anyone here in Klein v. Klein?
Yes, Your Honor.
Who's here for
that? I'm Robert Miller, Your Honor. It's not my motion. I was just going to be here to say I didn't have any objection to my opposing counsel withdrawing.
Is Mr. Leak here? I thought I saw him. Mr. Leak, you need to unmute, please.
Yes, sir.
Leak, I can't hear you. You need to speak up.
Hear me now?
Barely. So what is so tell me what's going on, Mr. Leak.
Well, I've known my client for probably 10, 15 years. He's a very good man, but he's very tight with his money. And I think he feels like going forward that he can represent himself better than hiring an attorney. And actually, we had reached a settlement, and that kind of fell apart. And so I think going forward, he just wanted to either represent himself and deal directly with the plaintiff's attorney. It's a brother suing a brother.
That's too bad. Okay. And is your client here?
William Robert Klein is my client.
Go ahead.
We had sent him a request that if he wanted to object, send him the Zoom instructions, and he sent us an email this morning and said, I do not oppose or object to your obtaining an order to withdraw.
Okay. Sounds good. You have a non-jury trial coming up in May, so I'll go ahead and sign the order, and we'll go from there. Thank you so much.
Thank you, Your Honor.
Thank you, Your Honor.
Our next hearing is on, let's first deal with the scheduling conference. We have a 10 o'clock scheduling conference on Mora versus Millican. Are both sides here for that?
Yes, Your Honor. I'm Laura Rivas for the plaintiff.
Anyone here for the defendant? Okay. When would you like to go to trial on this?
What are my options? What do you have available?
You just pick a date and I'll set it, because I have no idea when we're actually going to be able to get back to trial. So
do you have anything in January?
This is a brand new case, right?
Yeah, but I think, okay. What about fall of 2021?
Typically, we do 8 to 10 months at minimum.
I see, I see. I'm just hoping this one settles soon, given my conversations with opposing counsel. Do you have anything in fall of 2021?
Sure.
All right, we'll take it.
When exactly?
Let's do.
We could do September 7th, September 14th, September 28th, October 12th. Weird, okay. October 19th, October 26th.
Let's take October 26th.
October 26th, okay. Have you been, Ms. Rivas?
Good, how are you?
I just want to get back to trial, but it's.
I know, I feel you. I feel you, I agree.
I just keep, they keep throwing up roadblocks, so we'll see what happens. So, but we're going to do whatever we can, so.
Okay, I'll be seeing you shortly in some other cases for some hearings.
Great. Well, say hi to your whole team there, okay?
Will do. Thank you so much.
Good to see you.
You too.
Anyone here on Compass Data Centers versus Trout?
Yes, Your Honor. Good morning.
Good morning.
Good morning, Your Honor. It's my motion.
Good morning.
Your Honor.
Mr. Hirsch, are you there too?
No, I'm co-counsel with Mr. Hirsch for Mohammed Fotu, but we are not part of this motion. We're just attending, Your Honor.
Sounds good. Tony, let's go on the record on cause number DC 2011957. Counsel, make your appearances.
Ashley Tremaine appearing on behalf of defendant Bitbox Holdings, Inc.
Your Honor, Jeff Mills and Skylar Parker on behalf of Compass Data Centers. Ms. Parker will be handling the argument today.
And Your Honor, Sean Hamada for co-defendant Mohammed Fotu.
Okay. If I recall correctly on the special exceptions, okay, why don't you start your argument, actually? Go ahead.
Sure, Your Honor. There are three claims primarily that we are concerned with on the special exceptions. The first one is a fraud claim. And as you know, there's a bit of a heightened pleading standard when it comes to fraud claims. I think a lot of these cases say you need to prove the who, what, when, where, and why of the fraud. In this case in particular, we have, I believe, 9 parties in the case. The fraud claims are pled as sort of a universal, like 3 of the defendants all made representations, and the petition doesn't state which individual supposedly made these statements, what was said, when it was said, which is of particular importance in this case for reasons that I put forth in our special exceptions. And so that's sort of the first most basic issue, is just we're requesting that they be required to replead the fraud claims with the required level of specificity. Also on the fraud claims, there is a mention kind of tossed in that somehow this was done as part of a conspiracy. But it doesn't say what parties were supposed to be part of this conspiracy. 3 of the parties we're talking about are 2 individuals and a corporation. And as you know, a corporation cannot be a part of a conspiracy with its own owners or members. And so we're trying to get some clarity on what exactly they're arguing here about a conspiracy. Finally, on the damages on the fraud claim, they just sort of state broadly, well, we've been damaged. And I certainly am not going to argue to you that they have to give us a specific dollar amount or anything like that. I mean, I know, you know, I'm usually on the other side of these things. I don't plead dollar amounts, so I'm not alleging that. But I do think in a fraud claim in particular, and it's particularly when we're dealing with so many different parties and so many different claims, there are 18 causes of action here. It's fair to at least require them to state the form of damages. So are we talking about reliance damages or expectation damages? Are you claiming you lost a client? Like, what exactly happened that is the basis for this claim of damage? So that's pretty much it on the fraud claims. I cited some case law there in the special exception on the sort of general concept that when you're pleading fraud, you need to be a little bit more specific about the who, what, when, where, and why of the fraud. The next one is on a breach of contract claim. The way this is pled, again, it sort of just says, reciting the O'Connor's elements of the cause of action. There was a contract, you breached it, we were damaged. And I think that we are entitled to a bit more specificity on that, in particular, because at least my understanding of the breach of contract claim is they're claiming that some of the representations and warranties in the contract were breached. In the particular contract at issue, or at least what I think is the contract we're arguing about. I mean, there's, I think, 46 separate representations and warranties by the defense side alone. And so I think we're trying to just figure out what exactly they're claiming here without having to waste our limited number of interrogatories and deposition time in order to hound this stuff down. I mean, just as an example, on these breach of contract claims, I can't tell you how many conversations I've had with my co-counsel for the other defendants, like, well, what do you think they're claiming here? And we go back and forth, and everyone kind of has a different conclusion about what we think this petition is supposed to be saying. And particularly, again, on the breach of contract, I actually already sent requests for admission saying, can you guys just confirm that this is the contract we're talking about? And those were denied. So we just need to know, what is the contract? What is the clause you're saying was breached specifically, and how? Finally, the last issue is they are requesting a constructive trust. That requires there to be a specific identifiable race that can be traced. It's not clear in the petition what they're claiming that race is. The only thing that's kind of described in there is cash proceeds, which wouldn't be the appropriate subject of a constructive trust. And so we're trying to figure out, is there something else there? My client is sitting here trying to, run a business. He just had his third child. We need to know what of his assets are potentially being subject to this trust here. And so those are the three issues. Again, it's the fraud claim, the breach of contract claim, and the request for a constructive trust. And all we're requesting is that they be required to replead with some more specificity on those issues.
Hans.
Yes, Your Honor. May I share my screen? I have a quick little PowerPoint.
Okay. You can. Okay.
All right. Great. Thank you. All right. I know Your Honor knows the standard, but quickly, all that Texas requires is a short statement of a cause of action that gives fair notice to the adversary so that party may adequately prepare a defense. And that's it. The question for you today, Your Honor, is can an opposing attorney of reasonable competence examine the pleadings and conduct relevant discovery? And opposing counsel's conduct over the last 2 months has already affirmatively answered this question for you, but we'll get to that in a moment. Plaintiffs did more than satisfy the notice pleading requirement. They filed a 31-page petition with 179 numbered paragraphs. The factual background alone is 13 pages long. Additionally, each claim is identified with a bold heading that shows which plaintiff is asserting the claim against the specific defendant and includes more than just a recital of the elements of the claim. And plaintiffs know they met the standard because opposing counsel has issued 220 requests for admission, 21 interrogatories, and 116 requests for production based on this petition that was filed only 2 months ago, which is why the court does not see a single word of argument that says defendants can't get what they want through discovery, because any complaints about plaintiff's factual allegations now seem moot because of this discovery. For example, defendant complains that plaintiffs failed to identify the specific contractual warranties breached in the petition. Interrogatory number 2 that defendant sent asked plaintiff to identify those contractual warranties. Defendant complains that plaintiffs failed to identify the res for the constructive trust. Again, interrogatory number 4 specifically asks us to identify that res that we allege in paragraph 74 of our petition. Defendant complains that we failed to identify the date of specific misrepresentations, but defendant served at least 15 requests for admission regarding the timing of specific misrepresentations identified in the petition. So defendants are basically asking, their special exceptions are basically reading like a no evidence motion for summary judgment or a federal motion to dismiss, but special exceptions aren't held to those standards. And defendant has been unable to find Texas case law that says otherwise. For example, defendant is asking this court to require plaintiffs to plead the who, what, when, and where of their fraud claims. That's the pleading standard under Rule 9 of the Federal Rules of Civil Procedure, not Texas. The only Texas case defendant purports to have cited to, it cites to a proposed order. In what actually happened in the case is the court denied these special exceptions as shown by the January 23rd, 2009 ruling. So the case cites to the December 23rd, 2008 filing, which is an unexecuted order. In reality, the court actually denied those special exceptions in the end, which is what the court should also do today, because plaintiff is not required to plead every factual detail, only give notice. And defendant has not identified any other supporting case law that establishes plaintiffs failed to meet this burden because they didn't. So we're asking that the court overrule defendant's special exceptions. Thank you, Your Honor. Stop
Okay.
here.
Your Honor, if I may make just
Oh,
two very brief responses.
Okay.
On the fraud claim, the section that you saw from the petition, where they pointed out that there are bolded headings identifying which party the claim is asserted against. The problem with that, as you'll see, is that it's asserted against the holding parties, which is a group of 3 different defendants. And then it goes on to say the holdings parties universally made these representations. And so I think what we're entitled to know is which individual, who said it, not broadly 2 individuals and a company somehow together did this. And on the
Can you
issue
give
of
me
the
the example in their petition about what you're talking about, like, so I can see what you're saying?
Yeah, hold on,
Share
let me
screen.
see if I can do a share screen real quick.
I do also know, Ms. Tremaine, that you're frequently in federal court. We don't have to follow Iqbal here.
Yes,
So.
no, and I'm well aware of that. But I do think we do have an issue here of inadequate notice, which is why I've had to send discovery requests. And just, so Your Honor understands that particular issue, which was going to be my other point, the interrogatories that I sent are still outstanding. And as I told counsel prior to the hearing, I would like to withdraw those. I shouldn't have to waste my limited number of interrogatories to find out very basic information like this. So, Your Honor, this is the first cause of action. Can you see my screen?
I can.
Okay, so we have a fraud claim, and as you can see, it says fraudulent inducement against the holdings parties, plural, altogether. Earlier in the petition, and I'll see if I can find it, but they defined the holdings parties to mean Bitbox Holdings, Inc., Jonathan Trout, and Mohammed Fotu. So as we scroll down, it's just sort of, okay, the holdings parties either directly or part of a conspiracy made untrue representations of fact. And then we see, the elements of the cause of action here. And so what we're trying to figure out again is who made the representations and when, and what did they say? And it's true that this petition is extraordinarily lengthy. Hold on, let me see if I can get back to Zoom here. Okay, it is extraordinarily lengthy, but the problem is we have this massive fact section, and then it's not entirely clear how or which of those facts are being used to support the actual causes of action, which are then pled in this boilerplate fashion. And this idea of attorneys of reasonable competence, as I've already explained, there are 5 defense attorneys on this case, and we have this conversation nearly every week since this case began of us going back and forth, like, what do we think? I think this is what this claim is trying to say. And then someone else will say, I don't know, I think maybe they're trying to get at something else. And we're going back and forth on this. So I think this is we're not asking for more facts to be pled. We're asking for them to clearly tell us which of these facts are you relying on to support your actual causes of action here? Because again, there's 18 of them. So when you have that many facts pled and that many causes of action, it is not obvious. It's not like a car wreck case or a single plaintiff wrongful termination case, where the facts that you're pleading very clearly and obviously lead to only one cause of action. And yes, I am aware that there is a difference between federal and state law, but I do think this is getting to the point where we do have a lack of fair notice on this. And I should not have to waste in a case, again, where there's 18 causes of action and I only have 25 interrogatories, I shouldn't have to waste 4 of them to find out who they're claiming made a statement and what it was and what the race is and things like that.
Your Honor, may I have a brief response?
Sure.
The discovery is 25 interrogatories per defendant. So each defendant gets to ask 25 interrogatories. So each one gets to ask questions about what representations that they believe that specific defendant made. And if we look at the petition, Your Honor, I mean, this is not your ordinary bare bones petition. Oh, I'm sorry. Yep. Oh, hold on. Let me pull. How about I pull up the right one? There we go. I mean, we are talking.
Kids. Were those your kids? Cute kids.
Thank you very much. Yes, 4-year-old and a 1-year-old. But we go through facts and identify each defendant that we are talking about during these facts. So the holding parties, it's not like we just say defendants throughout all of these factual sections. We actually identify it by the specific defendant we are talking about. And each claim is identified by the bolded heading. I just gave you one example. We can go through all 18 of them, and each one has it identified by the specific party. We think this is definitely over and above a bare bones petition and and meets the notice requirement here.
Have you guys conferred on this at all?
Yes, Your Honor.
Yes.
Have conferred, and there's been no agreements reached?
No.
No, Your Honor.
I mean, I tend to think that you're, Ms. Tremaine, that you probably are trying to get them to require more than they would be required to do in state court. That
Your Honor, if I could, sorry, I will have you, the order I did, if you want to take a look at it, I mean, if you're going to deny it, obviously, then that's the easy thing to do. But
so you have a checklist order for
yeah,
me?
I have a checklist style order. So if there's anything,
where is that? I don't see it.
it was filed last night and accepted this morning.
The last thing that I see in this case was there was an order granting Pro Hoc VJ of David Guidry. That's not what we're looking for, obviously.
No. And I mean, I think both parties have filed proposed orders, so they should be on file. It may be that the clerk hasn't accepted all of them yet, but I thought I received a notice this morning saying that what we filed last night had been.
It's possible the clerks have it and I just don't.
Okay. I can screen share it for you if that's helpful, but I'm assuming you probably just want to.
I guess what I would suggest is go ahead and send it to Rhonda. We have only our actually our first live hearing that I've had since COVID is about to start. It's a contempt action where we may have to put someone in jail, unfortunately. But anyway, so I need to get to that. Why don't we do this? So you have a checklist order. Why don't you email that to Rhonda? I'll go through it. If I need an additional argument, I'll just reach out to you guys.
And Your Honor, real quick, before I know you have to break, I just want to make one thing just kind of clear here. And I think Ms. Parker did an excellent job, but I do want to point out that to the extent that they're asking for more pleading, we still have no guiding standards of what that is. They pick and want the who, the what, the when. We don't know what that means in Texas courts. We just don't. And say that you do grant the special exceptions. We could be right back here on special exceptions when it would make more sense, more efficiency for the court when we go through the discovery process. And if they say they don't have enough through discovery, they can ask for more discovery. So I'll just leave you with that, Your Honor. I think the lack of guiding principles here, what would lead us to kind of give them what they want, just does not exist in Texas court.
Okay. Thank you, guys. Email me the proposed order. I'll go through it. And if I need additional argument, I'll let you know.
Thank you, Your Honor.
Your Honor.
Thank you, guys. And email that to my court coordinator, Rhonda.
Okay, thank you, Your Honor.
Thank you.
All right. Is there anyone here on any other cases? Ms. Prue, are you here for something?
Yes, Your Honor. Paul Janinder and I are both here for the 10:30 hearing for the Valdatero that you were mentioning earlier, the motion for sanctions.
Okay. I don't know how this is going to work exactly because I thought that you guys requested that Mr. Wade appear in person. We have the arrest team here for him if we need to use that.
And Judge, this is not our motion. Obviously, it's Pete Harry's motion. So we're the co-defendant. So we're just here to really
watch.
Yeah.
I apologize. We're going to do the best we can. I need Tony. Where's Tony?
Okay, so is it time for me to come in the courtroom now?
Yeah, you need to come in the courtroom, please.
Okay, I'm gonna have to set up. Okay.
Where's Mr. Harry? Are you here, Mr. Harry? You come right over here. Are you Mr. Wade? Okay, who's this gentleman here? And I need to bring in Mr. Wade and anyone else involved in this case.
I don't think so.
What?
I don't think anyone else is involved.
Other than Mr. Wade?
Yes.
Okay. Okay. Ms. Simmons, you guys need to put on masks. Is this Mr. Wade? You Mr. Wade?
Yes.
Okay. Let's go on the record on cause. Is there a Mr. Rowland involved in this case? Aaron Rowland?
No, I don't think I've heard that name.
Okay, it may be another case. Okay. Rhonda, do you need something? Or Mr. Duran, is he involved in this case? Okay. All right. So let's go on. Tony, you ready? once the court reporter is ready, we'll get started.
Thank you, Your Honor.
Let's go on the record on cause number 206209, Luis Valdataro versus Richard Wade. Counsel, make your appearances.
Your Honor, Pete Harry here for the plaintiff and the movement.
Mr. Janender.
Your Honor, Paul Janender and Amanda Prue, Weil Gottschall and Manges from defendant William Mills. Thank you, Judge.
And Joshua Bennett. Is he involved in this case? Okay.
I don't think so, Your Honor.
Okay. And Mr. Wade, please make your announcement. All right, let's go ahead and proceed. Are you able to hear what's going on here? What's going on over here?
Judge, we can't hear. The only person we can hear is you.
Everyone was told to be here. I'm not sure why you guys are remote.
We did not get that notice. I'm sorry.
Okay.
But Judge, I don't want to hold up your hearing. So we'll make do, of course.
I'm sorry. I want to give everyone a fair opportunity here. What would you like me to do at this point? I'm open to.
Judge, I'm not at all suggesting that the court should not proceed. I'm not suggesting that. I don't think the relief sought in any way is directed at Mr. Mills at all. So in all seriousness, there's no objection from us. Please proceed, of course.
Okay. If at any point you feel like you want us to stop the hearing, let me know.
I will, but I appreciate that offer, Judge, but we're not going to impede the progress of the hearing, of course.
Okay. Mr. Harry, I'd ask you to speak into the microphone. Mr. Wade, you need to speak into the microphone and speak as loudly as you can so that Mr. Janender can hear, if possible. All right, let's go ahead and get started. You may proceed, Mr. Harry.
Thank you, Your Honor. Your Honor, we would, I think the court may be aware of what this is. Just briefly, the court had a hearing on August the 24th to impose an injunction against Mr. Wade for violation of the Rule 11 agreement that the parties had entered into. Subsequently, we provided to the court an agreed order that was signed by counsel for both Mr. Wade and Mr. Mills. Mr. Janender is correct. His client is not involved in this in any way. And no one has made a suggestion that Mr. Mills is somehow involved in what is going on here. There was somewhat of a delay because the court had ordered a mediation at that hearing. And the mediation started the following Wednesday, I believe the 26th, and it continued off and on for a number of days. And then finally, the court signed the agreed order on the 13th of September. We filed our bond on the 15th, and I forwarded a copy of the bond to counsel for both sides. Subsequently, Your Honor, Mr. Wade's counsel had filed a motion to withdraw, and they withdrew his counsel, I think, effective either the 5th or the 6th of October. We then, immediately after that, we had filed a motion for sanctions. Prior to that, based on information we got from Mr. Holder, who is the witness who's been subpoenaed to testify today. We then had Mr. Wade personally served with the relevant documents in the case, the notice of the hearing set, the motion for sanctions, the injunction order and also a copy of the earth garnish. At that point, we also had him served with that via certified mail, and I have the green card. I don't know if it'll be necessary, but he signed for that on October the 14th so he was given personal service and he was also given certified mail service. Subsequently, Your Honor, we believe that the witness continued to violate the terms of the injunction, and we have subpoenaed Mr. Holder to testify, and I would like to call him as a witness at this time.
So let me ask a question before we get started. So one of the remedies, as I understand that you're asking for, can you hear me okay, Tony? One of the remedies, as I understand that you're asking for, is criminal contempt. Is that correct, or contempt?
Yes, Your Honor.
And that would that potentially require jail time, I guess, for Mr. Wade? Is that one of the things you're requesting?
Yes, Your Honor. As we indicated in our motion for sanctions, this witness is, the defendant has a number of judgments against him and tax liens. You may remember from the hearing, Your Honor, on August the 24th, that I brought up the fact that he'd just been willfully violating the Rule 11 agreement.
So let me ask this, because obviously with the pandemic going on, I'm a little concerned about putting him in jail. Have you considered maybe doing a receivership over his assets? Maybe is that something you would consider as opposed to putting him in jail? Or,
Your Honor, we didn't really consider that because actually there is a receivership against Mr. Wade.
okay.
I guess we could ask the court to take judicial notice of the case that's in your court that was styled Robert Mokhtarian versus Richard Wade, where Mr. Mokhtarian actually obtained a receivership against the assets of Mr. Wade in May of 2019.
Okay.
And so I understand.
So how is he still able to do all of this if there's a receivership in place?
Well, I'm not sure what the status of that is. I understand there was maybe some agreement that was in effect that under Rule 20 or under 21002, under which we're proceeding, we have only an option of a $500 fine under the Civil Practice and Remedies Code, and we're not sure that that would even do any good against Mr. Wade. We understand, and I think Mr. Holder could probably confirm this, but on the 23rd of July, we understand that Mr. Wade's automobile was repossessed, and that's when he started using Uber, as the court will see from the evidence, 6 or 7 times a day. So we think that the most that in terms of an award that could be awarded against Mr. Wade would be $500, which when we put on evidence that he had taken approximately $8,500 out during the Rule 11 up until the hearing, his counsel, I believe Ms. Figueroa, said, well, that's not a lot of money. That was sort of her response to it. And we just don't believe that under the circumstances, I don't think that Mr. Wade really has the, number one, I think under this proceeding, we can't really ask for anything more than $500 because it's criminal contempt. And I'm not sure that he would be able to come up with that. I'm sympathetic to the court's concern about COVID.
I just was asking it, just something to consider. All right, Mr. Wade, I have to give you certain admonishments before we start with this proceeding. Sir, if you could state your name for the record.
Richard Wade.
Mr. Wade, you have the right to be represented by an attorney If I find that you are indigent, I will appoint attorney to represent you. Do you believe that you are indigent?
No.
Okay. You may give up your right to a lawyer and represent yourself if you elected to do that. Okay. If you choose to represent yourself, you may change your mind at any time and either hire a lawyer of your choice or accept the one that I appoint. Do you want time to hire a lawyer?
No.
I hereby inform you, Mr. Wade, that we are going to proceed with this hearing. Do you understand what we're doing here?
Yes.
I hereby inform you, Mr. Wade, that if I find you are in criminal contempt of this court, and if I assess punishment and confinement in jail, I do not plan to order that you be confined for more than 180 days. Do you understand that?
Yes.
So I'm not going to consider a contempt finding at this point of more than 180 days. I hereby inform you, Mr. Wade, that I will consider both criminal and civil contempt as possible punishment in this matter. The burden of proof for criminal contempt will be beyond a reasonable doubt, and the burden for civil contempt will be by preponderance of the evidence. Mr. Harry, you may proceed.
At this time, call Mr. Holder to the stand.
All right, Mr. Holder, why don't you come on up here? Mr. Holder, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, you may proceed.
Give your full name for the record, sir.
Freddie Glenn Holder.
And what is your relationship to vertical computer systems in this case?
I'm the accounting and finance consultant.
You're not actually an employee of the company.
No, I'm not.
But you act as an accountant for the company, correct?
Correct.
And in that capacity, are you aware that the parties back in May of this year had entered into a Rule 11 agreement between all the parties concerning what Mr. Wade could and could not do with respect to the finances of the company?
Yes, I was.
Okay. And were you aware that you had been appointed in that Rule 11 agreement to monitor Mr. Wade's activities with the checkbook and with the company debit card?
Yes.
Now, was Mr. Wade an employee of Vertical or one of its subsidiaries?
He's an employee of Vertical.
And did you understand that as part of the Rule 11 agreement, if Mr. Wade wanted to spend more than $100 at any point in time, that he had to get your approval ahead of time for that?
Yes.
And were you aware that he was not allowed to use the firm debit card for anything other than business purposes?
Yes.
And were you aware that he was not allowed to make any ATM withdrawals from the accounts of either Vertical Computer Systems or Now Solutions, its subsidiary?
Yes.
And where was the, where is the corporate office of Vertical Computer Systems?
It's in Richardson, Texas.
Is it currently possible for you or Mr. Wade to get into that space?
No.
And why is it not possible for you to get into that space?
Because we were delinquent on our rent payments and the landlords changed the locks on the door.
And when did the landlord do that?
I don't know the exact date.
Was it about the 1st of October? Is that
Roughly.
roughly? And how, do you know, as the outside consultant, do you know how much the rent was every month?
Yes,
How much was it?
about $7,800.
So the money that Mr. Wade took out during the pendency of the Rule 11 agreement could have paid the rent for 1 month, at least.
Yes.
You've been appointed, also, do you understand that this court granted an agreed injunctive order on the 24th of August, correct?
Yes.
And were you aware that you had, that basically it exactly tracked the restrictions in the Rule 11 agreement?
Yes.
And did you understand that you had the same, if you would, gatekeeper capacity with respect to the agreed temporary detention order?
Yes.
And following the hearing on the 24th of August, did Mr. Wade continue to use the company debit card?
Yes.
Did he continue to use it to, in some cases, withdraw cash from ATM machines?
Yes.
Did he continue to write checks to himself?
Yes.
Did he use the card to go to Costco to get various things?
Yes.
And were you aware that on or about the 13th of September, Judge Hoffman signed the agreed injunction order?
Yes, I heard that.
And since the 15th of September, has Mr. Wade continued to use the company debit card?
Can I look at my record?
Yes.
Yes.
And just to back up a little bit, on or about the 23rd of July, did Mr. Wade have his automobile repossessed?
Yes.
And how do you know that?
He had told me.
And so on the records that you have, that's about the time that Mr. Wade started using Uber on a daily basis.
That's correct.
And were you aware that he was not allowed to make charges other than with respect to an automobile rental agreement that he had in place?
That's what I assumed. It was not that clear on the Rule 11 agreement.
Okay. Are you aware that he has any other agreement with Vertical that just says if he wants to, he can hire transportation for any reason he wants to?
I'm not aware of it.
Do you know whether he was using the Uber card for Uber Eats?
I don't know that. I don't know if he was or not.
When you get the records for the use of the debit card, in what form are those records?
It's electronic. I go to the website, and is that what you're referring to?
Yeah.
I go to the website and look at the transactions that's come through on a daily basis.
And you are appearing today pursuant to a subpoena duce tecum, is that correct?
Yes.
And have you brought records with you?
Yes.
And what records have you brought with you?
I brought records through today of the usage of the debit card by Mr. Wade.
Does the document that you have also indicate the instances in which he may have written checks to himself?
Yes.
Okay. Has he written any checks to himself in the last week?
On 10/23, there there was a check for $65. On 10/20, there was a check for $120. On 10/16, there was a check for $100.
Did he get your approval before he wrote these checks to himself?
On these particular checks, he did not.
Did you discuss with him what the purpose of these checks were?
No.
I would note that in prior documents that you provided to me and other counsel in the case, there's a notation on there typically that says a charge for past due pay and allowances or for future pay. Are you aware of those annotations?
Yes.
And was that something that Mr. Wade told you to put in there, or you know why that annotation was present?
You're referring to my document?
Yes.
The cash withdrawals I always take to his past payroll or his overdue payroll.
Okay.
And he asked me to put the Uber charges against his payroll that was passed as well.
Okay. And you are not aware, are you, that there's any exemption in the either the Rule 11 agreement or the court's injunction that says that he can pay himself payroll indirectly through using the debit card or writing checks to himself?
I'm not aware of anything.
And just so we're aware, have there been payroll checks issued to the employees of Vertical Computer Systems?
Earlier this year, there was probably a few.
Right. And do you know whether Mr. Jim Souls, who's corporate counsel, do you know whether he's gotten any checks at all this year?
Not very many, if any. I can't recollect all the way back to January, but he has not received payment in many months.
Okay, and the major subsidiary of Vertical, which also offices at that location, is Now Solutions USA. Is that correct? Did Mr. Wade, when he's doing these debits, is he doing them against a bank account of Vertical or its subsidiary Now Solutions?
Both of them.
So he's going back and forth using Now, the bank account for Now Solutions or for Vertical, correct?
Correct.
Okay, the majority of the instances that you find in which he has been using the debit card, is that as against the Now Prosperity Bank account, or is it a Vertical Prosperity Bank?
I would think the majority of them are coming from Now Solutions.
And he is not an employee of Now Solutions, is he?
Well, we put him on the phone of Now Solutions because we normally allocate a third of his time from Now Solutions. So earlier this year, we put him on the payroll of Now Solutions at a third of his total salary.
Are you aware that any of the charges that he made under Uber, for example, that any of those were business related?
I don't know. I didn't really look at the two, where he traveled from and where he traveled to.
Do you know, as you look at the records that show you when the Uber charges were made, do you know whether or not those indicate whether they are for, say, charging Uber Eats and meals that he has delivered to himself, or whether they are for some business-related thing that he does?
I haven't noticed that any are for Uber Eats. I think the majority of them will probably go into and from work.
And do you have any idea what the charge typically is from his residence on Cole Avenue to the company's office in Richardson?
My best guess would be $20, $25.
Is that a one-way or is that?
That would be one way.
Okay. If he has an Uber trip or something other than the $20, we don't know what that's for.
Correct.
And he's also, if you would go back to your records, starting on or about the 16th of September, can you tell us how many times he's written checks to himself and in what amounts?
Yes. Okay, on 9/16, he wrote a check for $360. On 9/18, he wrote a check for $1,500. On 9/21, he did an ATM withdrawal of $103. There was another check on 9/21 written for $200. A check on 9/22 for $160. Check on 9/24 for $800. ATM withdrawal, $63 on 10/5. A check on 10/8 for $400. A check on 10/9 for $420. A check on 10/13 for $150. $150. A check on 10/16 for $100.
And these were all in the vertical computer systems Inc. account.
All of the ones I'm referring to right now came from the Now prosecutor's account.
And is that a subsidiary of vertical computer systems?
Yes.
Okay.
$10/20, $120, $10/23, $65, and